I don't have anything for a PowerPoint, but yeah, just have all my.
Soon. Test.
Right. We got to wait for the ringmaster to come down here and introduce us. We don't really exist until he tells you who we are.
I didn't mention this to our two speakers, but this program tonight is recorded, and you can see it tomorrow through Zoom. And we have about 150 people online observing this throughout the state of Minnesota tonight. Can you hear me now?
Yes.
Okay. First of all, I want to welcome all of you tonight to the Rosenmeier Forum, in which we will hear from two of Minnesota's outstanding jurists, retired Minnesota Supreme Court Justice Barry Anderson and former District Judge Jude. The Rosenmeier Center for State and Local Government at Central Lakes College was established in 1988 by then CLC President Sally Inney to remember the legacy of Gordon Rosenmeier. Rosenmeier, as many of you know, was regarded as the single most powerful, the most influential, and the most respected legislator in all of Minnesota history. Rosenmeier represented Crow Wing and Morrison counties in the Minnesota Senate from 1940 to 1970, winning most of his many re-elections without opposition. Gordon Rosenmeier would have been most pleased that we are having a program here tonight on the Minnesota judiciary. I say that because the fate of the rule of law and the system set up to implement the law was very, very important to him. While Gordon often described himself as a simple country lawyer from Little Falls. But in truth, the truth was that he won many cases before the U.S. 8th District Court of Appeals in St. Louis, Missouri, and also several winning cases before the United States Supreme Court in Washington, D.C. I want to provide you now with the background of the two speakers here tonight. Jude is someone I have known for a long time, as we were both elected to the Minnesota House of Representatives on the same day, November 5th, 1972. And I knew, before I knew Tad, I knew his parents very well. His father was Vic Jude, a longtime state senator from Maple Lake, and was a close friend he was in the state Senate. I used to remind Tad that I got elected as a poor farm boy, but he had the advantage of a well-known name at that time in his election. But anyway, Gordon Rosenmeier and Vic Jude were best friends. They were fishing buddies and hunting buddies together. In the House, Tad, in 1981, was named the chairman of the Minnesota House Judiciary Committee. And in that role, he chief authored the law that created the Court of Appeals, the Minnesota Court of Appeals, a new court system that layered between the district courts and the Minnesota Supreme Court. I remember at the time of the creation of the new court that it was sorely needed because in order to reduce the huge backlog that had of cases that were appealed to the Supreme Court from the district court level. So sometimes cases before the Supreme Court took months and months and sometimes probably a year or two before they got to it. In 1982, Tad was then elected to the Minnesota State Senate and served until 1988 when he won election as a Hennepin County Commissioner. In 2010, Tad Jude won election to the District Court as a judge from the 10th Judicial District, encompassing 8 counties that included Anoka, Sherburne, and Washington counties. Together, those 8 counties have a population of almost 1 million people. In his legal career, Judge Jude was an advocate for judges to be elected rather than appointed. I might also mention 2 times that Tad Jude made history. One, he is the youngest person ever elected since 1858 to the Minnesota legislature. He was elected at the age of 20 in 1972. You had to be 21 under the Minnesota Constitution, but I believe, Ted, your birthday is December 13th. And he turned 21. And his opponent took that case to the Minnesota Supreme Court. And the court ruled in a unanimous ruling then of, I think, 6-0 or 5-0. Now they have 7, I believe, on the court. And at that time, so he won that case and took the oath on January 3rd, 1973, as the youngest legislator in all of Minnesota history. The other time he made history, interestingly, was when he was elected a district judge. And I'm not going to go into the details of what caused it, but it was a snafu or big brouhaha in which the judge resigned after he had filed, or he withdrew as a candidate, leaving an open contest for the court in which there was no primary. And believe it or not, 25 people filed for the judgeship in that district. And Tad won. It was, when I say he made history, he won decisively in a campaign that was the longest ballot in Minnesota history. Tell me if I'm wrong, there were 25 candidates on the ballot. 24, okay.
He would remember that, you know.
I thought it was 25, but anyway, Tad is a graduate of St. Thomas College and the William Mitchell College of Law in St. Paul. Tad resides with his wife, Jacqueline, in Maple Grove, and Jacqueline is here tonight. Our first speaker tonight on the program is also someone who I have known for a long time. Justice Barry Anderson is no stranger here at Central Lakes College. He admires this college and has been a great speaker here several years ago. I thought it was 6 years ago, but you said longer than that. So we're really pleased to have Justice Anderson back tonight. Justice Anderson is a 1976 graduate of Gustavus Adolphus College in St. Peter, Minnesota, and is a 1979 graduate of the University of Minnesota School of Law. He was appointed to the Minnesota Court of Appeals in 1998 by then Governor Arne Carlson and served there until his appointment to the Minnesota Supreme Court in October 2004 by, I think, Governor Plenty appointed you to the court. He retired from the Supreme Court in 2024 when he reached the age of 70, which is the mandatory retirement age for judges in Minnesota. I don't know how many states have that, but we are one state that does have it. I mentioned to Judge Anderson earlier tonight that the U.S. Supreme Court, when you're appointed for life, and that's in the Constitution. But at the time the Founding Fathers wrote the Constitution, the average age for males was 35 years old in 1787. But we've had justices on the U.S. Supreme Court well into their 90s. John Paul Stevens was 94 and still very sharp when he left the court a number of years ago. Prior to his judicial service, Justice Anderson practiced law in Hutchinson, Minnesota. He also served as Hutchinson City Attorney for 10 years and was very active in his community organizations. Justice Anderson has also served several terms on the Minnesota Judicial Council, which is a principal administrative body for the Minnesota judicial system. And I remember that the governor makes a number of appointments to that court or to that body, and they also, that, as I recall, Justice Anderson, that organization screened a lot of the candidates who aspired to be district judges or
So that's the Judicial Selection Commission you're thinking of, Steve.
Commission.
The Judicial Council is an internal administrative body,
Yes.
which received its charges from then Chief Justice Blatz. It used to be that all of the administrative power was lodged with the Chief Justice. She voluntarily assigned that to the Judicial Council, which includes not only the Chief Justice and an Associate Justice, but it includes the Chief Judges of all 10 of our judicial districts, among others.
I'm very glad that you made that clarification for me. I have also, and thank you, I have also asked Justice Anderson tonight to speak briefly about a great Minnesota governor who he knows a lot about, and statesman, Harold Stassen, a Minnesotan who almost went to the presidency of the United States in 1948. Barry's uncle was Bernard Levander, whose brother was Governor Harold Levander in the 1960s here in Minnesota, and Harold Levander was a law partner in the same law office as Harold Stassen in South St. Paul many years ago. Both of tonight's speakers will talk about the past, present, and future of the Minnesota court system. Both know a lot about it. So without any further ado, it is truly my great honor to introduce our first speaker tonight, Justice Barry Anderson.
We'll see how it goes. We'll see whether or not you want to applaud when it's all over. We'll see how the evening goes. I'm delighted to be here. This is at least the second time I've been to speak here. I've been here several times to Brainerd because the District Judges Association often holds its annual conference here, and appellate judges go there to be told by the district court judges what we're getting wrong. So I'm delighted to have my colleague and friend for many years, actually long before either of us were ever serving on our courts with me tonight. And the way we've discussed this is I've got some remarks to make, I've got a PowerPoint, and he's going to interrupt me at any point that he wants to cover any other topics or to correct me if that's necessary. It might well be necessary. I do want to say a couple things about those two individuals that were mentioned by Steve in his introduction. Since it's the Gordon Rosenmeier event, we have to tell the obligatory Gordon Rosenmeier story. And I actually have a very tiny connection to that story in the sense that I am the son of the late Grant Eugene Anderson, died in 1965 when I was 11. But he had been active in Republican politics in the 1930s, had met Gordon during that period of time, and also into the 1940s. When he returned from the war, he drove for Governor Ed Thigh during his campaign in 1946 and had some conversations back and forth with Mr. Rosenmeier. Significantly, one of those conversations had a direct effect on me, arriving some years later, because my dad, having taken the low or no income job of driving a governor around, needed to find some way to make a living, and he had a couple of franchise opportunities, one in Mankato, one in Little Falls, and there's a letter in my what survived from my dad writing his friend Gordon saying, "Sorry, Gordon, we're going to Mankato, not Little Falls." Maybe there was a response from Gordon, we didn't see it. But anyway, that letter's been donated, and it's somewhere here in the Rosenmeier archives. No need to look it up because that's about all it said. My dad was not one for long speeches. I did want to say a couple of words about Harold Stassen. He is, for most of us, most of younger people, my three kids and their generation, it's a name dimly recalled, if at all. And for many of us in the room, it's a name associated with multiple presidential campaigns that were mostly a joke, not to Stassen, but certainly perceived that way. But he was a remarkable figure in Minnesota history. Youngest person ever elected governor. He began his career as, I think, the youngest county attorney to ever be elected in Dakota County. He joined the law firm of Elmer Ryan. The law firm later bore his name. He created the first government civil rights commission. He employed the first African American in a responsible position, actually as a military aide. Went off to war to fight during World War II, was elected 3 times as governor, and then came back and was a serious and legitimate candidate for president in 1948. Probably he had won several primaries. Had he won the Oregon primary, he might very well have been the Republican nominee and likely would have beaten Harry Truman. Didn't work out that way.
You know what, at this point, I just want to add a little bit about Gordy Rosenmeier. Gordy Rosenmeier was a good friend of my dad, and they'd go out hunting and fishing together. And what I think that points out, in a way, is that, you know, Gordy Rosenmeier had a brilliant mind. I mean, he had a good intellect. He was a terrific legislator. He chaired, I believe, the Judiciary Committee in the Minnesota Senate. And this is when Minnesota was known as a good government state. I mean, if you go back into the 60s and the 70s, you had Wendy Anderson on the cover of Time magazine, and we had the good life in Minnesota. And Gordy Rosenmeier, I think, is responsible for many of the departments and having efficient and effective government that really worked well. But it wasn't his intellect as much as just the relationships that he built. He was a conservative. We didn't have a party-designated legislature back in the 60s. It was 73 when we got into a party-designated legislature. It's kind of like the county boards. You have the county boards in Minnesota, they're not party-designated. City councils aren't party-designated. County attorneys aren't party-designated. Judges, you know, if you look at the back of the ballot, judges aren't party designated. That's the way it was for the legislature. And Gordy Rosenmeier was conservative. And they had a majority in the Senate. My dad was a liberal, known as a liberal, but he's a pretty conservative liberal.
Different era.
But that's what made Minnesota really work well, is that you had that relationship building. You know, people would go out fishing together, they'd go out hunting together, and it was a way that Minnesota government, I think, seemed to work very well, and Gordon Rosenmeier was able to master that. I'm one of 4 or 5 governors to serve under Gordy Rosenmeier, and he was a governor. But, you know, he had his fingerprints on everything that went past. Now, I do remember there was one time he got a traffic ticket, and this was he was out with some of his friends, I think fishing or hunting, and one of his other friends started arguing with the trooper. Now, if Gordy had been talking to the trooper, I think he would have gotten a warning, but he ended up with a ticket. Anyway. Those are the stories I have.
So when you talk about Gordon Rosenmeier, this simple country lawyer thing that this trick that he would try to play on people, I think he's a Stanford Law School grad, if I recall correctly. So he may have been a simple country lawyer, but he was a very smart, simple country lawyer. We were fortunate. We were fortunate to have him. He, incidentally, when Harold Levander was governor in 1966. Levander was probably the last of what I would call the old-style governors. If you called the governor's office, there was a 25% chance that Governor Levander would pick up the phone and talk to you. This doesn't happen anymore. But Gordon Rosenmeier and he were very close, and no legislation moved without Gordon's permission. So an important piece of Minnesota history, and Tad and I are delighted to be here as part of the programming for this evening. Maybe he'd appreciate us, maybe not, who knows. So let's move on, talk a little bit about our program. We're going to visit a little bit about the court system in Minnesota, how it's organized, what it does. Tad and I are going to have a little conversation about some issues as we go along. And then we hope to have some time for some questions afterwards, which we may or may not be able to answer. Let's see here. Oh, you know, it helps if you push the right button. There we go. Let's try that. There we go. Oh, it's going the wrong direction. All right. I thought we'd start with a little piece of Minnesota history. You have before you, you heard reference from Steve about the 7-member Minnesota Supreme Court. That's not written in stone. The legislature can actually change that. And in 1857, when Minnesota was getting organized, these 3 gentlemen, Charles Flandreau, Emmett Lafayette, and Isaac Atwater, were our first Supreme Court. And you may recognize those names, not because they're Supreme Court justices, but because there's a park named after Flandreau, a city named after, and cities named after Lafayette and Atwater. You know, we've been reading a lot about how we don't get along as well as we should. Let me just tell you that when the Minnesota Constitution was drafted and eventually approved by the Congress of the United States, we had 2 separate constitutions because the Republicans and the Democrats didn't get along. This is not a new development. It was so bad, in fact, that they met in separate rooms, and the only reason they finally agreed on sending a particular constitution forward is the word came back from D.C., we're not interested in 2 constitutions, send us one. This is your current court. Just so you're aware, justices sit in order of seniority, the Chief Justice in the middle, to her immediate right, Ann McCaig to her immediate left, Paul Thiessen, and then Sarah Hennessy, Gordon Moore, then our last 2 justices there, Sarah Hennessy on the end, and I can't see. All right, there we go. This is
Barry, I'm just going to point out, when they came up with the Constitution back in 1857, it was a year after Dred Scott.
Right.
And the Dred Scott decision was U.S. Supreme Court. It was terribly unpopular in Minnesota that minorities would not be treated as full citizens. And I think that's one of the reasons we ended up putting elections in the state constitution. We put it in because all this, I'd say 2/3 of the states have elections for judges. And we have that in Minnesota. Now, they're not contested the way they are in Wisconsin, but we have elections for judge in Minnesota, I think, because we incorporated right after the Dred Scott decision by about a year.
Yeah, and I think this is worth pursuing. I do want to finish up here. I didn't get the correct order here, order of seniority. Justice Hennessy is our most recent member. She is on the left side there. Justice Gaiatis on the other end is the next most recent member, and then the next most recent member is Carl Procaccini. He's in the back row there. I wanted to make sure we get everybody properly identified there. So let's talk about, I think you introduced the topic. Let's talk about judicial elections. We have 292 district court judges, 19 Court of Appeals judges, and 7 Supreme Court justices. But incidentally, I have the honorific as a retired member of the court as a justice. If you check our Constitution, all it says about judge, it says judge. The word justice never appears in Article 6 of the Constitution. Sort of interesting. I've had people apologize. They'll say, well, I'm sorry I called you judge. You're not you have nothing to apologize for. We're all judges. That's the reference to in the Constitution. Everything else is additional. But Tad's right. We didn't, in fact, I think there is some specific reference on the floor of one of the constitutional conventions that one of the principal drafters, who incidentally I believe shows up in 1858 in Chicago for the endorsement of Abraham Lincoln, he is actually present there for that convention, said we're not having anything to do with appointment model judges because they're the ones that gave us Dred Scott. Tad, what do you think about judicial elections? Yes, no, maybe?
You know, you've got a real, I would say, conflict. You have a huge conflict. You know, Madison, when he came up with the U.S. Constitution, one of the drafters, came up with these three different branches of government. You got the executive, you've got the legislative, and then you've got the judicial. And having these three branches of government, they're supposed to keep all the other ones in check. You know, they each have their jobs. You know, the legislative is to set policy, executive is to carry it out, and the courts are to be kind of the referees, decide cases that are right before them. And of course, in the U.S. Constitution, you have the members of the U.S. Supreme Court appointed for life. Now that's judicial independence. So you have, judicial independence over here, where you're appointed for life. That's it. And then on this side, you have accountability. So you have judicial independence versus accountability, and that's the struggle that we've got in the judicial system. And you see that play out today, I think, nationally. You've got one of the big issues I think that we have to address as a country and as a state is what they call nationwide injunctions. Where you have one judge in a federal court that would have a nationwide injunction. What that leads to is a lot of judge shopping. There's really no accountability, in a sense, for federal judges. They're appointed for life. I think they do have a retirement age, but then they do senior judge work, that kind of thing. But you don't have accountability. Now, in Minnesota, we do have accountability because we do have elections. But it's kind of a hybrid. I mean, most judges that end up on the Minnesota District Court are appointed by the governor. And the governor gets advice from a judicial selection committee that interviews the candidates and vets the candidates and this type of thing. And then, they're up for a re-election, and it says on the ballot you're an incumbent. So unless you really mess up, Minnesota judges generally are independent. They have judicial independence. Now, who are the ones that eventually get beat? I mean, a couple have gotten beat. I mean, I'm familiar with one who had like 3 DWIs. Well, you got to have that. You got to have that accountability. I'm familiar with another one. There were questions raised about steering legal business in the midst of his divorce, and he didn't win re-election. And I know another one that had a terrible courtroom manner. Yeah, people did not feel welcome in the courtroom, and everybody wanted to have their day in court. So those are the kind of issues that can come up and eventually would defeat an incumbent judge in Minnesota. But they really have to mess up.
So the other side of this coin, and you may be sensing that there's some difference of opinion on this, the other side of this coin is, although I agree with the way Tad has phrased it, I think it is a spectrum between judicial independence on one end of the spectrum, and accountability on the other end of the spectrum. When you have fully contested elections with a great deal of emphasis on what the judge has been doing, you've got a fully accountable system. The federal system is a fully independent system. But here's the problem. The problem becomes, what do these campaigns look like? I think if we were assured that judicial election campaigns in Minnesota would remain as they have been since 1916, when we went to nonpartisan judicial elections, I think I'd feel comfortable in keeping the system. I don't believe that we're going to be able to do that. I think we're heading for some trouble. Now, I've been saying that for a while, because I'm going to jump in here, because otherwise Tad's going to point out that he and I have been having this conversation for about 20 years, and I've been predicting that we're going to have this problem, and it hasn't happened yet, and that would be a legitimate criticism of my position. But we did have partisan judicial elections for a period of time, about 1892 or 1896 to 1912 or thereabouts, and there were 7 incumbent Supreme Court justices who were defeated during that period of time. We went away from partisan judicial elections to nonpartisan, and in the post-World War II environment, we've only had 2 open seats, 1946 and 1992. Otherwise, it's been incumbent justices on the ballot, and the incumbent has won. So the question is, though, is the experience in Wisconsin, where over $100 million has been spent in the last election cycle, just completed this spring, approximately equal amounts by both sides, is that coming to Minnesota? I happen to think that there is some risk that it is. And the problem with my position, candidly, is what do you replace the existing system with? There are 37 states in the United States that have some form of judicial election, either the kind Minnesota has, or partisan judicial elections like Texas, or retention systems like Iowa and Missouri, where you're just asked whether or not to retain the judge. The other 13 states are mostly on the East Coast, and they are mostly states that don't have elections. No state, since we started adopting judicial elections in the 1830s, has ever voted to go completely away from judicial elections. In other words, no state has gone to a federal model. What you see are states going to retention models. Minnesota had a chance to do this in 2010. There was a serious effort made. Ultimately, no constitutional amendment passed the legislature to go on the ballot to make this change, and it would require a constitutional amendment. So my position has been that we should be thinking about some form of retention election. I think Tad will tell you that there are some issues with that approach. But the present situation is such that I don't think we're going to make any changes in this system unless and until we have a crisis. You want the last word?
Okay. You know, part of the reason you get contested judicial elections has to do with the issues that come before the courts. And if the courts are involved in setting policy, people are asking for accountability. You know, that should be made by the legislatures. It should be made by Congress. It should not be made as much by the courts. The courts are limited to the cases that are brought before it. They're limited to individual disputes involving the parties that are in the courtroom. Now, what you saw going on in Wisconsin had to do with policy. I mean, they were talking about every, hot issue you could imagine in a judicial race. Now, there was an educational component of that. I mean, people don't know a lot about the court systems in Minnesota. They know a lot about the court system in Wisconsin because of all the money. I mean, $100 million spent in a race for the Supreme Court in Wisconsin. It's because they were getting into policy issues, and people wanted to have a voice in that policy. That shouldn't be where the courts come into play. And I think that's how Minnesota has distinguished itself, and I think has done a good job. Now, I don't like retention elections. The reasons I don't like it is you've got insiders, people who I would call elites, that are on these committees. Might be all lawyers. They'd have cases before the court. They're deciding, whether a judge does a good job or not. And then they put a recommendation before the public. The public only has one person to vote for or against. It's not a race between two candidates. It's one candidate, you vote yes or no. I mean, you'd see that, in my mind, in the Soviet Union, or you'd see it in Cuba. You wouldn't see it in the United States. It's not really an election. It's not democracy. I think people want to have democracy. I think we've got a hybrid. It says incumbent on the ballot, that's educational. And you just really have to mess up if you're an incumbent judge to be thrown out. But there is some accountability. So you have some independence and you have some accountability. And I think that's a good way to do it.
And if the circumstances in Minnesota do not change, I think Tad has made a very good argument for not making any change. If they do change, we may regret not having done so. But we will leave that debate where it sits. There's going to be more opportunity to have a conversation about that in the months and years ahead. I don't think we're done talking about this problem. All right, let's go back to the judicial branch here. There are some statistics up there. I'll let you read them for yourself. Like I said, it's a little awkward here in terms of looking at those numbers. The one thing I want to point out that is worth considering, when we talk about our district courts, our Court of Appeals, and our Supreme Court, the heavy lifting is done at the district court level. The district courts, I tell student groups and groups like this, that probably somewhere around 800,000 cases get touched by a district court judge in some way or another. The actual number of cases handled probably exceeds a couple million, but that includes the various tickets, the one that Gordon Rosenmeier got, or those of you who might be traveling too fast on 169 between Minneapolis and Mankato and just outside of St. Peter where it isn't marked well, and you might get a speeding. This is all hypothetical, by the way. I don't know why I happen to have this hypothetical in mind, but you might get a speeding ticket there, and that would be included in the 2 million because you're probably guilty and you're not going to challenge it. But if you want to challenge it, you're one of those 800,000 that appear before our district court judges. There's a real difference between the work that the appellate courts do and the district courts do. And Tad, I'm going to look to you. Tell our viewers and our folks today what the life of a district court judge looks like.
Well, you could probably ask Jackie. She would give you a better idea. But, the district courts have, and we've got a couple district court judges here tonight from Crow Wing County, I believe.
They're critiquing our performance. We'll get the ballots from them when we're done.
I'll take questions, but if they are real difficult questions, I might refer them. But I would say the courts in Minnesota are really going through a change, a huge change. And part of it has to do with technology and the pandemic has changed everything. And if you go to a law firm today, you'll find that it's probably at least a third smaller than it was 15 years ago. Because law firms have really hollowed out, certainly the major cities. And if you look at our courthouses, our courthouses are not nearly as busy as they used to be. Because there's everybody going remote. Everybody is doing the Zoom meeting. And in fact, tonight, this is going to be on Zoom. You have continuing legal education by Zoom. And
The number of cases hasn't necessarily gone down. In fact, it's gone up, but the way they're handled has changed.
I would say at least half the hearings that we used to have in person are now being held remotely. And there's a lot of advantages to that. I mean, you have people disabled who can't come to the courthouse. You have people who are removed from the courthouse. You have big counties that, you know, it's just difficult to get to the county courthouse. This is going to have a huge impact in every county seat of Minnesota. We've got 87 counties, of course, and we all have great courthouses, but they're all built for the old system. So there's going to be a downsizing of the spaces we need for county government. And, you know, we were talking a little bit about how the courts are organized. If you go back in Minnesota, we used to have like municipal courts for traffic tickets, and county courts, and then district courts. Well, now we have a unified trial bench, but then we have the Court of Appeals, and then the Minnesota Supreme Court, which is a smaller court, used to be 9, and then that was made 7. But I think we're going to have to wrestle with how to deal with the new space needs of the court system. And we've gotten rid of all the paper files. Everything is filed electronically and stored electronically. We don't need all the file rooms. So just like law offices have changed a lot, and I know we got the Rosenmeier law firm here, the Keller law firm in Little Falls, and you know, every law firm has changed a lot. And I think that's happening in every courthouse in Minnesota. We have to wrestle with it.
Yeah, it's, and of course it's changed at the appellate level as well. Although we have gone, the Minnesota Supreme Court has gone back to in-person oral hearings, and we use Zoom only for special circumstances, out-of-town lawyers, out-of-state lawyers, things of that sort. So we're not as affected by the issues that that Tad has described, but it remains a challenge. And those numbers that you see up there, cases handled, are still going up. The question of, you know, whether or not it's better or worse is complicated because it's kind of both. Maybe my preference for in-person hearings reflects my age and bias. On the other hand, you'll get disagreements among our district court judges about that, and among lawyers. My original thought when the pandemic hit and we were going to move away from in-person hearings while the pandemic was underway, and then elected to continue that, is that lawyers in Greater Minnesota, which is a constituency I very much am concerned with, because that was my practice years ago. I assumed that there would be issues with client retention, Minneapolis, St. Paul, Twin City type lawyers sort of moving in to Greater Minnesota. But when I talk to my colleagues practicing law here, some of those concerns are present. But what I also hear is that it's a real advantage to both the lawyers and the clients in terms of not having to drive to courthouses. You talk to public defenders, not so much public defenders, but civil legal aid lawyers, you'll get kind of the same story, that it may actually have proven beneficial in some respects.
Now, I could tell you stories about what not to do, either in a Zoom hearing or in the courtroom. In a Zoom hearing, I've had cases, you know, when I was a judge, where somebody would be appearing from their bedroom, and the bed wasn't
don't
made.
do that.
And you almost expect the bed to start moving. and you know, I mean, yeah, I've had cases that were traffic cases where somebody's appearing from a moving car, and I know they don't have a license to drive. I've had cases where people are appearing for a hearing and they're watching TV because they're real interested in that program. Yeah, so, you know, you have some decorum in the courthouse that makes a difference. Now, sometimes it doesn't make a difference. I've had people show up in the courthouse, with, of course, tattoos that say criminal intent or something of that nature. That does not leave a good impression with the jury. And many other shirts. I don't want to describe them. I don't know if I could describe them on the internet.
Yeah, let's not.
In any case, if you ever go to court, dress like you're going to a job interview. And if you ever appear by Zoom, have what would look like a courthouse setting or a serious setting. Take it seriously. And I have to say that social media has just changed court cases incredibly. And there are so many cases that it might have to do with, the courts deal with such important issues. They deal with your personal liberty, they deal with your property, and, it ends up the restrictions that you have to live by. And we end up with people bringing in a trail of what's been on Facebook that ends up determining who has custody of children or what hours you have custody of children. So you have to watch what you put on Facebook or watch what you put on Twitter or X or whatever they call it now, because that ends up being real important evidence. I can tell you one case that had to do with child abuse, and I've got stories I can bring from the courtroom, and this is something I can talk about because it's not on appeal or anything, but these little children looked like they had been battered by the bruises they had on their face. And the defense attorney wanted to see the phone that had those photos. And if you look at the phone, you could go back 12 seconds. And you'd see how shadows actually created those bruises on the children's faces. And you wouldn't have known it by looking at the pictures. But because of technology, you were able to see it. So technology has changed the courtroom completely.
For those of you who have had the good fortune to avoid any contact with the Minnesota Judicial Branch, I would note that district courts are trial courts. So when you hear Tad talking about those experiences, those are matters that are being tried in the first instance. As you would see on television, you have lawyers asking witnesses questions, introducing evidence, and so forth. The appellate courts, Court of Appeals and the Supreme Court, are they are record courts. So if you didn't get your evidence in at the trial court, you're not getting it in at the Court of Appeals or Supreme Court. And you will often read, you'll read in the newspaper about the United States Supreme Court, and they'll say, the Supreme Court made a narrow decision. And then, people who like the decision will praise it. People who didn't like it will criticize it. Welcome to our job. But what that probably means, or may well mean, is when you confine the case to the record that's before the court, it wasn't necessary to decide the broader or more significant question. A lot of times you'll see appellate courts that have discretionary calls as to whether or not to take a case. You'll say, well, why didn't the court take that case? Well, the court didn't take that case because there were problems with the record in the district court. Maybe some evidence wasn't introduced, or maybe there was some evidence introduced that really wasn't appropriate to the dispute. Some other problem with the record, the question of when to take a case and when not to take a case is a lot more complicated than simply, well, that's a really important case. I always, when I talk to high school classes, I'll tell them that I remember there was a case long before I became a judge, involved the Minnesota Twins, whether they were going to move to another place. There was a decision made by a Hennepin County District Court judge, and the Minnesota Supreme Court was given an opportunity to take that case. As a result of that decision, the Twins stayed in Minnesota, and they declined review. And so then the question becomes, well, what? It was a really important case. Why didn't they take it? Well, I wasn't on the court at the time. I don't know. I'm speculating. But I could look at that case and make a pretty good argument. This was an unusual set of circumstances. It was governed by a very detailed written contract. It didn't have any implications for other written contracts or other kinds of disputes. It was a unique set of circumstances. No need to take it. On the other hand, we took a case during my time on the court that involved the city of Lester Prairie. There were junk cars stored in the front yard of this home in Lester Prairie, town of about 1,000 people, maybe. Why is the Supreme Court taking this case? Why? Because every city in Minnesota has a junk vehicle ordinance, and every city in Minnesota deals with stored automobiles in the front yard. So that case doesn't look like it's as important as this big, important contract dispute involving the twins. Well, you know what? There's a pretty good argument that maybe this other case, this parent-little case, is actually more important. And that's the kind of analysis. Now, the Court of Appeals doesn't get to do that. Everybody gets an appeal. You get an appeal as a matter of right. Most of the time, that means it's going to the Court of Appeals, but the Supreme Court does make a call on whether or not to take many cases. Tad?
No, there are a couple cases when I drive up here I think about, and one of them has to do with the street right in front of the community college here. There was a case that went to the Minnesota Supreme Court maybe 15 years ago. I think it had to do with eminent domain and how that street gets built and how you have the roundabouts. Mm-hmm. And that's the kind of thing that went up to the Minnesota Supreme Court. There was a case that I remember from law school. It had to do with Johnson Cigar in Brainerd. And it had to do with it had to do with the homestead exemption. Because I think you could exempt a homestead in bankruptcy. And the owner of Johnson Cigar moved into the warehouse in Brainerd. So that was his homestead. And we learned about that in law school. That was a big case.
See, Brainerd's really important to the development of the law in Minnesota. We wouldn't, absent Johnson Cigar, we wouldn't know what to do with the homestead. So,
but there was a case out of Hennepin County just 3 years ago. It had to do with a woman named Tyler, and it went up to the U.S. Supreme Court, and it's been a real practice in Minnesota that if you didn't pay your taxes, the county would confiscate your land and your home and sell it, take all the proceeds. Well,
in other words, more than the taxes that were actually due.
Yeah, and Ms. Taylor had, I think she owed like $15,000, but her condominium was worth maybe $45,000 in Minneapolis. She was like 95 years old. She hadn't been paying taxes for 10 years. And so the Hennepin County took it, went up to the U.S. Supreme Court, and they said, and it was Chief Judge Roberts, mm-hmm. I think, that wrote the decision, Caesar can only take whatever Caesar is due, and not a penny more. And so Gwendolyn and Tyler ended up having equity of about $25,000 in that case. But all 9 of the U.S. Supreme Court members agreed on that case.
Yeah, it's sometimes the cases that are really significant, you look at them and you say, well, there's not a lot of money at stake here, but there really is. There's more to be said here about the precedent. Well, there's a description of what our various justices and judges do. Tad talked a little bit about the work that the district court does. That's not a comprehensive list, but it includes a lot of the matters that are handled by the district court. As I noted earlier, there are a few cases where the Minnesota Supreme Court has original jurisdiction. In other words, the dispute comes to the Minnesota Supreme Court in the first instance. For example, we had some matters involving the legislature this year. This was long after my time on the court, so I know what you know about it, which is what I read in the newspapers. But those were original jurisdiction cases. They go to the Supreme Court. Other kinds of election cases, judges have to the court and the Supreme Court in the first instance. United States Supreme Court does as well. And one of the most common is disputes between, let's say, between Wisconsin and Minnesota as to where the boundary line is. Those are original jurisdiction cases as well. The members of the Minnesota Supreme Court have both administrative and opinion responsibilities. I asked a law clerk once as we were finishing up the year. We have recent graduates of our area law schools and from some law schools around the country who come and clerk with the Minnesota Supreme Court for a year, basically August 1 to July 31 of the next year. And they help with research, serving as a bailiff in the oral arguments and performing other duties for the court. I asked one of my law clerks what she thought, what had surprised her about the experience of clerking for the court, and her response was, well, I thought what Supreme Court justices did was, think great thoughts and write them down and issue opinions. But it turns out they do lots of other stuff, and she was surprised at the volume of administrative work that members of the court do. I'm going to come back to that. This is a pretty good idea, sort of the global scheme of things. There are multiple rules committees, administrative bodies, and then there are special projects. And these were my assignments. You can see them up there. I'm not going to run through the list. It's not that interesting. Those were my assignments during my final year on the court. I was the liaison to the 10th Judicial District. I got to go to 10th Judicial District bench meetings and listen to Tad all the time. So this is nothing new. He's been telling me what to do for a decade or longer now. And I was also the liaison to the 3rd Judicial District, which is in the southern part of the state next to the Iowa border. Talk a little bit about bench meetings and what does that mean in your context as a district court judge?
In the 10th district, that's where I was elected. There are 8 counties, and we would have terrific bench meetings. Joe Quinn was the chief judge for a while, and I think there was one instance that got to fisticuffs.
Yeah, it was.
But in any case, we have very different counties. We would run from Kennebec, which is a one-judge county, to Anoka County, which has about 16 judges. I was out in Stillwater most of the time, and the one thing about our calendar, so to speak, and our calendar is basically the cases that we have. We would get a little bit of everything. So you have some juvenile cases, you have some real estate cases, you have a lot of family law cases, and about half criminal cases. So you get up to speed in a lot of different areas. Now you go into Hennepin County or Ramsey County, St. Louis County, you get people who specialize, like just juvenile, or just criminal, or just probate, and that's all they do. They know everything there is to know about those areas. But I really did like, the variety of cases that would come in, and as a district court judge, you see humanity. You see the best and the worst of what's going on in the community. And during the pandemic, things changed so much. It got to the point where law enforcement really didn't want to arrest people. They didn't want people to live in a congregate setting, where you'd have other people around. Everybody needed their own space during the pandemic, it seemed like. And you needed to have a judge at the courthouse, but you didn't want to have too many people around. You didn't have juries coming in. Pandemic, so things changed a whole lot. And that's why we got into the remote hearings. Now those are, if you're a defendant in a criminal case, you have the right to confront your accuser. So you need to have in-person hearings. But that's the hearing. You have a lot of preliminary hearings, you know, where you're arraigned, they set bail, you have motion hearings, you decide what evidence can come in, can't come in. Those kind of things, those are all done pretty much remotely now, but you still have the trial, you know, the evidentiary trial, that's the person. But that's why courthouses have to rethink how they're set up, because I think the court system has changed so much now that we have to address it. But the one issue that you see coming up nationally is that people are seeking judges that they think are sympathetic to their case because of the ability to have a nationwide injunction. And one judge, you know, that's appointed for life can make that decision with little or no accountability. Now in Minnesota, we have more accountability because we're on the ballot. But you're on the ballot in a particular district, and in the 10th Judicial District, you know, it's an area that's difficult to communicate with people. You're in the metropolitan media market, that type of thing. But I think we have to think about whether judges, individual judges, can have statewide injunctions. You know, you're really accountable to your districts. Now the state Supreme Court, State Court of Appeals, they run statewide. So you can see where they're, and frankly, you know, as a district court judge, I was happy to have an error correcting court that would look over my work. And I wasn't really reversed that often. Occasionally I'd be reversed, but the thing you didn't want is to have it remanded. Because if you had it sent back, then you had to do it all over again. You had to hear all the evidence again. So, you know, just decide whether you agree, disagree, but don't remand it. That's what we prayed for.
You know, this whole accountability thing and justice is really complicated. So, and here's why it's complicated. Tad gives you an example of the 10th Judicial District. How many judges are in the 10th Judicial District?
45.
45, and it's how many counties?
8.
8 counties, covering probably, I don't know, 1 million people maybe?
At least that. Yeah.
That's right, somewhere in that neighborhood. So if you want to run on the ballot, and we won't pick on Tad here, but let's say I'm a judge in the 10th district and you've had enough of my poor decisions and you want to replace me. You've got to run a campaign that's going to reach 1 million people in 8 different cities in the most expensive media markets in Minnesota. And the Minneapolis-St. Paul market, I think, is about the 15th most expensive media market in the country. In other words, I'm not sure, notwithstanding our earlier discussion about accountability, I'm not sure how much accountability there really is when you get into that framework. Now, the problem you run into is, okay, well, we'll shrink the districts, right? I mean, it used to be, when I started practicing law in 1979, you had a county court judge. In my case, it was Conrad Gernstrom, who was a wonderful, wonderful judge for a young lawyer to learn from. And he only sat on cases in Martin County, unless he was filling in for somebody in some other county. But when he's over there, he wouldn't be on the ballot in his county. So, for example, if we take the 10th Judicial District and say, well, we want to have more accountability, so we're going to cut it in half or thirds. Now you have to deal with judges who have conflicts. Everybody's, some judges can't sit on cases. You have to bring a judge in from outside. That judge isn't accountable to the voters who are there. So I guess what I'm saying is there's an air of unreality when we talk about accountability because of the complexity of how we're organized and the needs of judicial assignments. So where that might lead in the future, I don't have any answers. I mean, I think there's a debate to be had about, and the problem with the federal model is, as Tad said earlier, there's no accountability to the voters, right? I mean, the accountability is to the election of the president, who has the appointment authority, confirmation by the Senate. So I don't think there's a perfect model, and you have to weigh all those various factors. Let's see here. This just gives you some idea of kind of the Supreme Court's work product. I don't have really too much to say about that. A couple more points I want to make. Time to decision. Now this, we've got a couple district court judges out there, and I got one here. And if you talk about time to decision, the district court judges will remind you that by operation of state law, they have 90 days to make a decision. That 90-day limit does not apply to the Minnesota Supreme Court. I hear about this frequently. What I will say is the Supreme Court has made itself accountable to the Judicial Council, and as a member of that Judicial Council, it was my duty to report to the Judicial Council what our time to decisions are. When you have a collegial body, 7 members, it's more difficult to get, it can be, not always, but can be more difficult to get an opinion out because you got to get sign off on it. Famously, a member of the court who's no longer with us from a previous era was once asked about when an opinion could be expected, and that justice's response is, when I'm done with it. And so there is that to consider. But what you see there is a pretty good example of kind of what our average time to finishing is, and we've been working on getting that number down. But I can't tell you the number of times the district court judges, well, we do better than that. So, and they of course are not wrong. I just want to say a word about petitions for review. The Supreme Court has cases it has to take. First-degree murder cases come direct to the Minnesota Supreme Court. They skip the Court of Appeals altogether. It's the most important criminal case that's decided by district courts. We are both an error-correcting court, as the Court of Appeals is with other matters, and we're also the final word on judicial review in those matters. We also have, as I said, original jurisdiction in some limited other matters. And we also take cases from the executive branch courts. If you're looking for an issue that's been sort of percolating for some time at a national level, the question about administrative law and so forth, that's the kind of thing we get those cases as well. But the bulk of our work as a court is decided here, which is, are we going to take this case or not? This is the process I mentioned earlier when I was mentioning our friends in Lester Prairie and our junked automobiles. That case went through this process, and the 7 of us sat around a table and decided, are we going to take this case? Is it important enough to take? And it takes 3 votes to take a case. Why 3? Well, if you had a requirement for 4, that would mean that you would not be taking some cases where there's a legitimate dispute, but there might not yet be a majority. So you take 3. It takes 3 votes to accept review. And once accepted, the lawyers, only in the legal business would we call a document drafted by a lawyer a brief. But that's what we call them, and the lawyers will submit briefs. There used to be a time way back in the beginning of the Stone Ages when I started practicing law, limited briefs by page size or by number of pages. Problem with that is the lawyers found the key, the font key, and so we started getting 6-point and 7-point. So we put a stop to that, and we now have a word count. The lawyers haven't figured out yet how to get around that, but give them time. And then after we get the briefs, oral argument, and then the court will conference the 7 of us, no law clerks, nobody else present, and decide the case. Then there's the writing process. I won't go into that, but basically every opinion that's issued by the Minnesota Supreme Court is seen by all 7 members of the court. They've all signed off on it or written a dissent. That gives you some idea. Basically, between 500 and 600 of those cases come to us we take about 15% or so. All right. Things that we worry about as a court system is access to justice. We have a terrific civil aid system and public defender system here in Minnesota. I really do think it's the fact that it can use more both could use more resources. I think it is a pearl of great price for Minnesota. I think we have reason to be proud of it. That's an important part of getting access to justice. And one of the debates, incidentally, that's going on is the use of legal assistants. We would call them paralegals. In my era, as a lawyer, they were legal secretaries. They do a lot of work, and we have now permitted them, under some circumstances, in some courts to make appearances on behalf of clients who would otherwise not have lawyers available.
And I'd point out that in many counties you have a self-help desk where litigants that do not people, if their life or liberty or are at issue, they consult an attorney. But if for some reason they're not able to, at the self-help desk, try to get some pointers at the self-help desk. Every county has a law library, and a lot of times there are clinics, you know, what they call a clinic where an attorney will offer pointers for people who might have a family law case, might be discussing child custody or how to divide things in a family law case. And those clinics are very valuable to people. And you always have the computers there at the courthouse that are available to the public, so you can see what legal documents are there in your case.
I want to close my part of the remarks tonight with a few words about impartiality and courts in general. I just want to say that I think the American justice system, for all of its problems and issues, remains a pearl of great price. It is a jewel among other systems, and I point to the Bill of Rights as really an important part of that. I frequently will have, during my time on the court, I would have visitors who would come from other states, other countries. I had some military officials who came from the National War College one year, and I had a dialogue with a French military officer, I believe it was a general, French general, who said, "Excuse me, I have a question." And my question is, in a criminal case where the is found not guilty, how often does the state appeal? And I had to ask him to repeat the question because it was really kind of foreign to me. And then I said, well, in most criminal cases, the case is over if the jury comes back with a not guilty verdict because of the double jeopardy protections of the Fifth Amendment, among other things. And he was puzzled by that. It was not part of the French system. But that written Bill of Rights that we have is really significant. And I just want to say a word about our appellate court, the United States Supreme Court, Minnesota Supreme Court, other Supreme Courts, which is that I do think what you see is an effort to get it right. Doesn't mean the final decision is always right, but it does mean that that goal is the goal of all appellate courts. And frankly and candidly, I think that because we don't know our own history very well, we don't know how often Americans have exercised their right, First Amendment, to criticize the judges that they employ. You know, this is something that occurs pretty frequently. And we've been seeing it here today. We've been seeing some criticism about the Supreme Court. Here's a sort of very detailed, you can take a minute to read that, I'll talk about it here, very detailed criticism of the terrible reasoning that the United States Supreme Court has used in a decision, and the author's really quite exercised about it, and the author's an academic of significant note, very unhappy with the way the court handled this particular matter. The critic happens to be Alexander Bickel in 1957. My point here is not the merits of what Professor Bickel had in mind, but to simply say the constitutional right of Americans to engage in debate about what courts decide is an important right that is protected. But I want to assure everyone watching online and here that the judges that you're appearing in front of at the district court, or the judges at the appellate courts that are reviewing the work of the district court, are really trying very hard to get it right. Even when you may sit there and think, as you are entitled to do, gee, we're not so sure about this. We prefer a different result. We have a few minutes left. Can we take some questions here? I think we've somebody here with the.
Thank you. I think
right there.
all right.
So when the census is done and they do redistricting, do the judicial areas get redistricted too, or do they stay the same?
Tad, you want to take that, or should I? Let me.
You know, that is an excellent that's an excellent question, and there's no good answer to it. It is not redistricted. You know, these districts are not redistricted. I think the Supreme Court for a while considered changing the districts, but because of all the administration involved in our judicial districts, they're in many ways, I think they're chiseled in stone a little bit, and a lot of it's administrative. But we are not redistricting. County is one district. You know, Ramsey County is one district. Now people say, well, Ramsey County is a lot smaller than Hennepin. You know, why don't you add like Washington, or why don't you add Dakota, you know, to that district? It's not going to happen. I don't envision it.
So this is a really great question. And in fact, the Judicial Council prepared a report several years ago, Access and Service Delivery Report, I think we called it, that debated this, and there was an extensive debate about whether or not we should redistrict, and the problems that Tad suggested were, of course, a large piece of this. But the fact of the matter is, we have judicial districts that vary widely in size in terms of number of and at some point we're going to have to grab that nettle, I'm afraid. The last time the districts were redistricted was 1987, I think, mid-50s anyway. And the first judicial district, which I'm most familiar with because I practice law there, extends from essentially just south of Litchfield through the south suburbs down to Red Wing. Not a lot of territory there. So, yeah, it's going to be an issue that's going to have to eventually be addressed one way or another.
Justice Anderson, how do you view the balance between public safety and individual privacy in rulings like the B case, where the interior of a vehicle was considered a public place?
So I'm not going to discuss the specifics of that, but I will just simply say that you know, that tension is reflected in those kinds of disputes, where what do you deal with privacy rights, but also public safety rights. And Minnesota has actually been more protective of privacy rights than the United States Supreme Court. So, for example, this is just one that occurs to me. Under United States Supreme Court precedent, law enforcement can conduct random stops of vehicles to determine whether or not there has been impaired driving. Minnesota doesn't permit that. You have to have cause to make the stop. So these are hard things to measure, or hard things to weigh, and reasonable people can come down on both questions, and that is one of the reasons why many of these cases frequently feature a court, 4-3, 5-2, and so forth.
I have a number of follow-ups, not just with that, but I have two other topics that I don't see a lot of engagement, considering that this is mostly viewed online, but do you believe that requiring permits for BB guns, particularly when tied to this expanded definition of public place, aligns with the principles and proportionality of fairness in law?
I have no opinion on this. Don't know anything about the issue.
All right. Then I'll move on. Given your experience in interpreting constitutional rights, balancing public safety with individual freedoms, how do you view the use of AI-powered tools like Overwatch in law enforcement? Specifically, how might programs employing hyper-realistic digital personas impact Fourth Amendment protections against unreasonable searches and privacy rights under the Constitution?
I wouldn't touch that question without extensive briefing.
I have no more further questions. Thank you.
Other questions? Other questions?
Dan, over here. Over here.
Sorry.
Sorry.
Quick question about the collections, I think was on the side, on that listed 100 million or something in that order?
Yes, correct.
I'm wondering if Minnesota is different than other states and then allowing forfeiture. In California, a sheriff took a bank truck and then turned it over to the FBI. And then he got 10% back. That county got 10% back. Is that possible in Minnesota?
Do you want me to sit up?
The issue of civil and criminal forfeiture is a huge issue, I think, involving law enforcement. And what I found, at least in the metropolitan area, is that I would say the law enforcement has had to rein in a lot of the civil and criminal forfeiture. That was a big issue with the war on drugs. It was a huge issue on the war of drugs, and it kept on getting expanded. And they ran into trouble in the metropolitan area where a lot of things were being forfeited that really weren't being used as a, and that was the theory behind civil forfeiture of, the tools of the crime were going to be taken by law enforcement. But it gotten out of control. And I think that was reined in by the courts. And that's why you have to have the courts, I think, use common sense. Yeah, and it's a lot less prevalent today than it was. I think law enforcement was using some of that to fund needs that they had, but it just got out of hand, particularly in the metro area.
This is one of those areas where there's shared responsibility between the courts and the legislature, because the civil forfeiture is a creature of the legislature, but it also implicates constitutional rights, Fifth Amendment and other constitutional rights. Actually, I think within the last 10 years or so, Minnesota went through a sort of a major reorganization of civil forfeiture, and as Tad suggests, not only did the courts rein it in, the legislature actually retracted some of that activity as well. Over there.
Being here. My question would be, do you think that the legitimacy of the judiciary, both state level and federal, it has been damaged by Citizens United?
That's a really good question. And so Citizens, for those of you who are unfamiliar with the decision, has to do with campaign finance issues and free speech, and the decision of the Supreme Court to limit the ability to regulate the campaign spending. And I think that, I think there are arguments on both sides of that. I mean, I actually think that the Supreme Court probably got it right on the First Amendment piece of this. That was a 5-4 decision. It was closely debated, but it's pretty clear there have been, I think it's fair to say, negative ramifications as a consequence of it. What you saw in Wisconsin with 100, the two most expensive state Supreme Court races in the history of the United States. I've been in our neighboring state in Wisconsin, both Supreme Court races, this one and one of the predecessor races. So now the reality is that even had Citizens United been decided differently, you would still have extensive campaign spending. And so would it make a difference? I don't know. So I guess the question is, the answer to your question is, I don't know that I can say that there has been a definite effect, but I think the argument that there's been some negative fallout from Citizens United with respect to judicial races, it's probably right.
You know, I have to say I'm not an expert on Citizens United, but from what I can pick up is that for decades, organized labor and those organizations were able to contribute to political campaigns, but corporations were not able to. And I think the theory of those 5 votes, a 5-4 decision, was that you had to have both organized labor and corporations for free speech. Now, I am real concerned about the impact of just, you know, hundreds of millions of dollars in campaigns, and not only judicial campaigns, but even, you know, campaigns for governor or campaigns for U.S. Senate. I mean, big money has a big impact on any type of campaign. That we're talking about free speech, and Citizens United was based upon free speech. There is an educational component. I mean, people know about Wisconsin courts, except for that campaign. Now everybody knows about Wisconsin courts. You hear about the Congress, or you hear about the governor's office, or the U.S. Senate through a campaign. I remember when I ran for judge, we had 24 candidates. They had to go out and get 500 signatures of people in the 10th district. But you don't just get people to sign up to put your name on the ballot without explaining what you're running for and why you have to run or why you want to run. Through that whole process, there was a lot of education going on. We would have candidate meetings, we would be out in parades, you'd be meeting people. I mean, it was an educational effort, and there was money involved, but I think that's the positive end of it. You know, if you have money spent in campaigns, there's an educational citizen engagement, civic engagement that goes with money in campaigns. So I think there's a reasonable amount. Now, one of the blessings we've had in Minnesota, I think, has brought us good government, is that we haven't had blowout money campaigns like they had in Wisconsin. But that's something where I think there has to be common sense and balance. And money doesn't always win. I mean, if you look at races, like for president, the best finance candidate doesn't always win.
Justice Jude, Justice Anderson, it's an honor to have you here at the college and have you here for this forum. And the question I'd like to ask you is how do you respond to the citizen critics of the timing of cases to be heard for citizens to be heard, and we hear a lot of the backlog of the number of cases that have to go through the judicial process. How do you respond to that? And is there a solution, or is there the solution is there looking for a problem?
So I've been around a long time. I started practicing law in 1979. We went through some phases, some budget some difficult budget circumstances where we were significantly understaffed. By that I mean we didn't have district court judges to handle the caseload, and it was necessary. In fact, I was involved in generating support, trying to prevent, as a practicing lawyer, trying to prevent the transfer of a district judge in Martin County to the Twin Cities. But there was more need for judge resources in the Twin Cities than there was in Martin County. And despite my best efforts to gin up support and persuade the Minnesota Supreme Court not to make that switch, I gave them all kinds of advice and they didn't take it. I don't understand, but anyway, they didn't. They transferred that judgeship because there was not enough money available. I mean, there was no possibility of going to the legislature, getting additional funding and adding judgeships. And we're kind of in that ball game now. I mean, some difficult financial circumstances. We're in the middle of what we call a weighted caseload study. We're trying to determine whether or not we have sufficient number of judges, whether the judges are in the right places where the workload is. And that study will take some months to complete and then some more months to sort of analyze and put together. And we'll be in a better position to answer your question probably a year from now when we've had a chance to look at that. This is a process, there's actually a fair amount of science to it. I mean, we aren't just putting a finger up in the wind and saying, how many judges does Crow Wing County need? There's associated with it. It's not precise like calculation of pi or something like that, but we'll have a better handle on this. My sense is we don't need a dramatic expansion of the number of district judges at this point. The Court of Appeals was expanded a few years ago. I don't think there's any need there, and I think the Supreme Court is probably, I think 7 is probably an appropriate number going forward for the time being.
First of all, thanks for coming. Previous to Enbridge's attempt to put a pipeline through Minnesota, they became a single contributor to campaigns in Minnesota for a couple of years, at least 2 years, maybe 3. And this was a lot of money. Shouldn't there be limits to foreign corporations that are contributing to, campaigns in Minnesota? It just seems ridiculous to let foreign corporations be the biggest contributors. And
that is a great public policy question that I refer you to our legislature on. I think it's their call. The courts don't have any jurisdiction to set those kinds of limits, and that is the whole question of campaign really appropriately laid at the doorstep of the governor and the legislative branch.
You know, that to mind a case in West Virginia where they had a member of the Supreme Court run for election, and it was a coal mining issue, and there was a major contribution, I think, by a gentleman named Massey in West Virginia, and it didn't turn out well for the Supreme Court incumbent who took the contribution from the coal industry. But you need to have disclosure. You need to have so that people know about it. I mean, if you look over to Wisconsin where they had major investment by someone who may have a case before the Wisconsin Supreme Court in a race, I think that was something voters thought about. I mean, you have to have that disclosure, and that is a legislative decision.
That's also an argument for the federal model, by the way. Anyway,
all right.
My last shot on that.
Kind of a question for both of you. It doesn't involve Minnesota, but in recent years there's been cases like that of Asa Baker in Ohio, where a child's lemonade stand was shut down due to a vendor's permit. While enforcement actions like these are intended to uphold local regulations, they often spark debates about balancing rules with fostering entrepreneurship in children. From your perspective, what steps should communities take to prevent such situations while encouraging young individuals to explore entrepreneurial spirit?
All I'll say about that question is that is a regulation issue, and I think you are correct to identify it as a problem. And I really wish that we spent more time as a culture, as voting citizens, as residents, thinking about whether we have too much, too little, or not, or the right of regulatory issues. I don't know the specifics of that case, but having peddled both lemonade, artistic rocks, and other sorts of non-marketable goods as a 5, 6, and 7-year-old, I certainly would not want the government interfering with my right.
And I don't know that case, but I do know in the city of Minneapolis, they just lifted a number of regulations on street vendors. So more street vendors in the city of Minneapolis, and I think that has to do with an immigrant population that is accustomed to having street vending in their home, the countries they've come from.
All right, we're going to take one more question, and then these guys are going to stay around and answer questions because we want to be respectful of everybody's time. So we'll just take one more, and then you guys are welcome to come up.
Thank you. I just had a question that was more kind of a curiosity, that you did a wonderful job explaining the process of the courts and the appellate courts, that they're really doing the best they can. They want to get it right, that it's the backstop to be sure that the court judicial system gets it right. I was curious your thoughts on pardons. What percentage you feel are that third backstop to be sure that everything got done right? Or what part of that is frustrating that after all the judicial process, it gets overturned? If that's too...
Yeah, well, you know, the question about pardons is a good one. Minnesota has a unique system. I'm not aware of any other state that has a model like ours. We actually had a case involving how the pardon system operates. It came before the Minnesota Supreme Court while I was on the court. And the process has changed a little bit now, but we have a pardon board composed of 3 individuals. The Governor General and Chief Justice. It requires at least 2 votes, including the vote of the Governor, to grant a pardon. There's some interesting history that I won't bore you with here about how we happen to get that pardon system, but it is set out in Minnesota law, and it's from my perspective, I'm not troubled by it at all. I mean, it's the process that the voters and the founders have chosen, and it's part of our system, and it's no different than our court, which might reverse Judge Jude here on a particular matter. You know, the participants in that case are entitled to take their case up in the appellate system, and the appellate system has the authority to reverse it if necessary. Similarly, if the pardon board in its judgment thinks that a pardon is appropriate, they're entitled to do that. And you're not going to hear, I'd be very surprised if you heard a member of the Minnesota Supreme Court complain about a pardon board decision. I suppose it's possible, but I don't think so.
I just mentioned that Minnesota is really probably way down, either the lowest or second lowest in terms of rate of incarceration by population. We have fewer people that are in prison in Minnesota as a percentage of any other state in the whole country, you know, or in the bottom tier in any case. The latest I'd say movement has been toward expungement, you know, clearing everybody in particular of low-level drug crimes. And expungement has been encouraged by the legislature. That's the only case where I know I've been reversed by the Court of Appeals, was I denied an expungement on a case, and the Court of Appeals reversed me. But that is a movement in Minnesota. Give people a second chance. Now, my view of it, pardons, talking about pardons, I like to have cases considered individually. you know, rather than like blanket pardons of everything that happened, you know, this particular day.